Good afternoon, everyone. Welcome to the Appellate Division, First Department. Oral arguments for today, October 26th. So you all are familiar with our practice. You are all familiar with the fact that we have read your briefs. We are fully familiar with your arguments. So again, please only request the time that you actually need to present your arguments. Obviously, if we believe that additional time is necessary, we will certainly continue to ask questions. People versus Stephen Jude.
Appellant requests 6 minutes and 1 in rebuttal, Your Honor.
I'm sorry? So you guys were not paying attention, but that's okay. 5 and 2 and 5. Barton Hall versus AFIAA.
Request 5 minutes and 1 in rebuttal.
For respondent, 4 minutes, Your Honor.
514. Marilyn C. versus Gregory F. That matter would be submitted. Lee versus the City of New York.
5 and 3, Your Honor.
535. Masumdar versus the Board of Managers.
5 and 2, Your Honor. Respondent 4 and 5, Your Honor.
Respondent what?
4 is 2 respondents.
I'm sorry, say that again.
There's 2 respondents, but I only represent 1.
Okay. Oh, more. I thought you were saying something else. Okay, 524. Goldfine versus Kohler. 525. People versus Raymond Castro. That matter would be submitted. Rosenthal versus Sperling.
Request 5 and 2, Your Honor. Respondent request 5.
525. People versus Anonymous. You know who you are. The matter is submitted. Capitas Servicing versus MS Health. So we have two appeals, right? Okay. So we're gonna do them together. So we're gonna do 5 for both. Is that okay? 5 and 2 for both. Yes. 525 for both. Esgro Capital Management versus Banks. 525. People versus Patrick Ross.
Appellant requests 4 and 1, Your Honor.
414. Colonial Funding versus Finley is submitted on both. First case for argument is People versus Stephen Jude. Who are these people? Whenever you are ready.
Good afternoon, Your Honors. My name is Richard Joselson, and I'm here today on behalf of Appellant Stephen Jude. Your Honors, in this case, the court's unjustified refusal to grant the defense motion to vacate Appellant's original unconstitutional plea was legal error that improperly induced the replea that is the subject of this appeal.
How do we know one had anything to do with the other?
I think we know it very clearly based on the colloquy of the replea itself, and let me explain. Let me just explain what our core argument here is, which is that the court explicitly created the specter that unconstitutional plea and that unconstitutional sentence of 22 years to life could still be in the mix unless appellant agreed to the replea.
And so where in the record does the court say that it could still be in the mix?
Well, it's actually a very unusual replea because it begins with the court saying, we're going to vacate the original plea, which if that were true, that would have been fine.
Well, didn't the judge have to vacate the original plea because there was an issue with the federal sentencing?
Well, I agree that the judge had to vacate the original plea, but that is not really what the judge did. Because what the judge did, and it becomes clear in the replea, as the allocution starts, the judge is doing sort of the traditional Boykin, allocution.
You made a 440 motion to vacate the original plea. You didn't below claim that you were being forced into the new plea by the old plea.
Well, but what we did do, and what his predecessor counsel did, is they made the 440 motion to vacate the plea. And then when the people responded to that 440 motion and did not controvert the essential facts, which was there had been a promise and the promise had not been fulfilled, defense counsel argued that the motion should be granted on the papers pursuant to 440-30 sub 3 or whatever it is. But the court didn't do that. The court said, no, I'm going to order a hearing of some kind on that. And that, I think, is the essential problem in this case. And it played out in the allocution.
You mean the judge was forced, the judge had no right to order a hearing?
Not on
whether the motion should be granted?
Not on the voluntariness claim, because there were two essential facts in this kind of voluntariness claim. Was there a promise? And clearly at the original plea, the court, on the record, promises concurrent time. There's no dispute about that. Second component, was the promise honored? It was not honored because the parties couldn't figure out how to transfer primary jurisdiction from state authorities to the federal authorities. So he was clearly serving a sentence of 22 years to life, effectively, which is 6 years longer than the sentence he had bargained for. The court needed to grant that motion on the papers. There was nothing else to do at a hearing, but the court...
But at the end, you didn't say below, oh, I've got to take this plea because of the 2016 plea.
Well, except what happened was when the court started the Boykin advisal, he told Mr. Jude, you have a right to a trial. And Mr. Jude replied, do I? Can I go to trial in this case? And the court said, well, not exactly. First, we'd have to see what happened to, what would happen.
440 motion.
If you won your 440 hearing. But of course, it's our point that 440...
Doesn't that sound like he knew what he was bargaining for?
I don't think it was a bargain, though. It's not a legitimate bargain if an unconstitutional plea is being held over your head. Yeah, he said, it's like, well, I have to take the 18 to life because you're telling me otherwise the 22 to life might still be there. If there was a legitimate sort of theory by which that 22 to life could remain, that would be one thing. But there was no such theory. That plea had to be vacated. The people argue that, no, maybe it was okay for there to be a hearing on that voluntariness claim, because maybe it would be relevant what defense counsel told Mr. Jude off the record about the promise. But that's not the law. The law is you determine what the promise was by looking at the record, and the record is clear.
So, counsel, what is it that you want us to do?
What I want you to do is to vacate the plea and remand the...
Vacate the 2018 plea.
Vacate the 2018 plea.
Right.
Remand for further proceedings.
What further proceedings?
Mr. Jude could proceed to trial if he chose, or we could try to negotiate a different plea. The truth is, I think an experienced defense attorney might be able to negotiate a plea.
Well, there were like 5 experienced defense attorneys, I think, total in the case, because I believe that the defendant kept filing complaints against the attorneys in this matter. So I think there were at least 5 or 6.
Well, that may be, Judge, but
I'm just saying that, so you want us to vacate the 2018 and then remand it for what further proceedings?
For us to negotiate a new plea or to proceed to trial. We may end up in the same place, but as
long as you don't end up here, that's fine.
Well,
but you have time. You have time on me, bud.
Judge, if you send this back, I promise not to return.
Thank you.
Good afternoon, Your Honors. Dana Poole for the people. This is a case where defendant got his original plea vacated, and he got the...
Did the people concede that the 2016 plea had to be vacated?
No, Your Honor. In most situations, that would be the case, that the promised sentence absolutely equals the defendant's understanding. Here, there were a lot of moving cogs in this decision, and the people put that at issue.
All along that there was a problem working this out with federal court.
Excuse me?
You were aware all along that there was a problem working this out with federal court.
That's right, but there's also the issue that defendant got sentenced in federal court to consecutive sentences and did not inform the state court of that fact prior to sentence. And that alone is grounds to deny a 440 motion. If defendant knew that there was a problem, did not alert the court to the possible problem, and then waited to bring a 440.
Is there any significance to the fact that the court vacated the 2016 plea prior to taking the 2018 plea?
Well, it was basically a negotiated disposition of the entire thing. So what defendant ended up getting was vacatur of the 2016 plea, and then he got the best possible plea deal on that indictment. The least he could have pled out to was a C violent, and the minimum sentence on that is 12 years. That's exactly what he got. If this were returned, there is not a negotiable plea that would be less than that, and certainly the court was not in a position to mandate that the people consent to that plea negotiation that they did at the time to wrap the whole thing up. And they had put defendants' understanding of the plea and what would happen at sentence an issue. And that's one of the things that Justice Caro was entitled to explore in a 440 motion. Defense counsel, appellate counsel from Cal, prior appellate counsel, had also put on the table that maybe effectuation was possible. Now, it's not clear that that actually was, but again, if it were possible, then that would have obviated the need to vacate the plea under the 440 motion. So there were all sorts of things in addition to...
But isn't there some sort of level of unfairness? The defendant agrees to concurrent time. He doesn't get that. And shouldn't the remedy then be vacatur of the plea under those circumstances?
Well, he got vacatur of the plea. And then what happened is that as part of, in disposing of the case that day, they also negotiated a very favorable plea under the terms of everything that was happening at the time. The fact that federal sentence had already been imposed, it was consecutive, the court had no power to mandate that the Bureau of Prisons or the federal court make any different decisions about that. And so what they were stuck with was the federal court was going to do whatever it could to ensure...
Is this claim that the 2018 plea was compelled by the failure to vacate by the 2016 plea, is that claim preserved?
No, Your Honor. They certainly could have made the claim at that court proceeding. Your Honor, we don't think that this should be decided on the papers. We don't think that we should have to be in this position. We think that you should just vacate the plea and then we start. For all we know, that may have been part of the discussion, but even when defendant was asking the court, can I go to trial? Can I? And the court said, yes, but we're going to have a hearing on this 440-10. Defendant was able to consult with counsel, and they decided that that was not the best option. For whatever reason, they thought that was not the best option. Perhaps they thought that he might lose that hearing, or perhaps they thought that even if he won, he might not get this good of a plea deal again. And so he opted, with the advice of appellate counsel, to have his original plea vacated and to accept a very favorable plea deal. And that's exactly what happened here.
So what was he ultimately sentenced to?
In this case, he was sentenced to 12 to life, which was the minimum sentence he could have received on that lesser crime.
So if we did, in fact, remand back for further proceedings, what would he be, what would the exposure be? The minimum is still 12 to life?
On the top count of the indictment, it would actually be 16 to life, and the people would not be obligated to offer a plea to the lesser crime that he was allowed to plead to in the 2018 plea. So we ask that defendant's conviction be affirmed. Thank you, Your Honors.
If in fact the 2016 plea had been vacated at the time the replea colloquy had begun, then we wouldn't be here. Then it would really be a clean slate decision that Mr. Jude would have made to accept the plea bargain to accept the plea bargain. But that's not what happened here. The court said that the plea was vacated, but as soon as Mr. Jude asked to go to trial, the court said, well, the plea's not really vacated yet, because first we would have to have a hearing that you could lose, and then things stay the same, 22 to life. If the court ultimately agrees that the 22 to life sentence violated the promise, then this whole procedure is induced by the unconstitutional plea. In terms
But again, I don't understand how the record reflects that. It was clear that it was illegal, that it was an illegal plea, right? And so now he's pleading guilty, not an illegal plea, but it would have been an illegal sentence or whatever. The court would not have been able to go forth with the sentence based upon what happened in federal court. So why now are you stating that there's any issue, or that the record reflects any issue as to the voluntariness of the defendant's plea?
Because once it was an illegal plea and that plea were vacated, he would have had a right not only to accept the proposed replea, but to go to trial, to try to negotiate a different kind of plea, to try to work with the federal authorities to get jurisdiction.
So that goes back to the issue as to the 440. Was there any statement by any attorney to the contrary that the defendant was not made aware of all of his rights?
Oh, he was aware what was going on, but what was going on, in our view, was not okay.
But what, in your view, but is your view backed up in any way by the record in terms of any affidavits? I don't know whether Perlmutter represented him at the time or who.
The face of the plea, the replea record itself makes it clear that if Mr. Jude declined to take the replea, he was still at risk of Judge Caro deciding that that original 22 to life plea might remain in effect. And that should not have been, because by that point, it was already uncontrovertibly clear that that plea was unconstitutionally obtained. It should not have been overhanging this replea at all.
So that's what you say to us today, and quite skillfully, I might add, that this 2018 plea was forced by the 2016 plea. But at the time it's happening, and it's a counseled plea, no one says, Judge, I have no choice but to take this plea, since I still have this 2016 plea hanging over my head. This is something which is now argued, but at the time it's happening, no one mentions it.
Well, I think Mr. Jude kind of mentioned it, and what he said was, can I go to trial? And that raised questions about the voluntariness of the plea. And we know generally that when a defendant's allocution raises questions about the voluntariness of the plea, the court has a sua sponte obligation to clear things up. And that's a
So
preservation.
can I go to trial translates to there's an issue with the plea?
Can I go to trial? The correct answer is, well, yes, if you want to, you can go to trial. The answer he got was, well, maybe not, because maybe...
Well, I don't know that the answer he received was maybe not.
Well...
And also, you know, Mr. Jude was no novice, right? He had a couple of priors. I think that's why he was a persistent, right?
As I say, he understood what was happening here. It's just he had no choice about it. He said, Your Honor, I would have to win the hearing to get a trial, right? And the court said, yes, of course. To me, yes, of course, was the incorrect answer. The correct answer was, yeah, that plea is unconstitutional. If you want to go to trial, you can go to trial.
Thank you. Thank you
those
both.
risks. Thank you.
Barton Hall versus AFIAA 158.
Good afternoon. Plaintiff appellants by Cyruli, Shanks, and Zismore, Robert Cyruli of counsel. If it please the court, the error in the decision of lower court is in its failure to apply or give any legal import to the unique provisions of the guarantee and the lease in the matter.
So sections 2, 5, and 8 is what we're focusing on. What's your view? Are those a complete waiver of defenses or not?
Section 8 of the guarantee, Your Honor, is distinct from, for example, CHIP. The guarantee in CHIP states that the guarantor is guaranteeing rental obligations under the lease. In our guarantee, in the condition precedent in Article 8 of the guarantee, our guarantor is guaranteeing a failure by the tenant to pay rent when due. When due. And we believe that that is a somewhat peculiar treatment and a treatment that drills down deeper than merely a rental obligation. There may be rental obligations under the lease, but a rental obligation may be subject to set-off abatement credit.
I guess my question to you, sir, is more the question of waiver of defenses, because I think that's really, so 8E, for example, says any defense based on a statute, rule of law, which provides the obligation of a surety must be neither larger in amount nor in other respects more burdensome than that of the principal. Isn't that essentially a full, a waiver of all defenses?
We would say no, Your Honor. We would say
Why?
because of that introductory sentence. And remember, this introductory sentence, as part and parcel of what Your Honor has cited also, is all under this paragraph or article that respondent has made great hay in its papers of saying it is waiver of defenses. Okay. But in the intro to waiver of defenses, it makes very clear that the guarantee applies to rent when due. That wasn't paid by tenant. When due. And again, we make that distinction between merely a rental obligation under the lease and rent when due. And we believe that that allows for the conditions, the exceptions that appear in the underlying lease, and that it was error for the court to not give them any weight.
Now, what
We
about
really-
Section
I'm sorry,
5?
Judge.
What about Section 5?
Section 5 of the
So
lease or
under-
the guarantee, Judge?
Section 5 of the guarantee, right? The guarantor waived any defense that could be deemed a legal or equitable discharge of a surety?
Yes, we posit that even in light of that, we have an introductory condition precedent. The money had to be due in the first instance. Not just an obligation of the lease, but it had to come due. And how could it have come due if there was, in fact, a partial actual eviction, which of course would mean no rent is due, or even a partial constructive eviction, which would lend itself to suspension or perhaps an abatement. But these are all material issues of fact that had to be considered. And we believe that once you acknowledge the condition precedent in the guarantee, that rent when due is a different threshold, a different standard, even than in CHIP, which the lower court cited to, then you have to look at 19 of the lease, that landlord had a performance repairs in the typical manner, minimizing interference, professional, that perhaps even Article 30, the abatement event in the lease, comes into play. But they need to be examined. There needs to be discovery. And quite candidly, the allegations were made below. They're part of the record. I'm saying in my client's affidavit of someone with personal knowledge, that meets the threshold of making the allegation. It is discovery that would essentially prove or disprove the allegation.
I'm sorry, and what would the discovery entail?
The discovery would entail an in-depth inquiry into timing, methods, scope of the work. Was it in fact done in a way to minimize interference with tenants' business?
Meaning going to your defense's actual partial eviction, et cetera.
I'm sorry, Judge.
Meaning going to your defenses, well, not your affirmative claims.
Right, but not broadly, vaguely, within the scope of Article 19 of the lease, where those claims are permissible under the lease if, in fact, landlord did not perform its work or entry in the proper manner. Similarly, under Article 30, if there is an abatement event, an access issue, we have it here, then these things can be entertained. And again, it is admittedly about the threshold in the guarantee. I don't
Thank you.
believe...
You have time on rebuttal.
I'm sorry, Judge?
I said you have time on rebuttal.
Very good, Judge. Thank you.
Good afternoon, Your Honors. May it please the Court. Donnie Schwartz of Offit Kerman for Defendant Respondent
How do you
Afia.
respond to the argument that this is unlike the generic waiver of defense provisions and guarantees? Here there is a condition precedent with respect to rents when due.
Justice Singh, there is no condition precedent. First of all, there are a number of these waivers, as the Court mentioned, as we mentioned in our briefs and sections, not just 8, but 2 and 5. But Section 8, the initiating sentence of Section 8 that the appellant relies on is not a condition precedent. All it says is that if the tenant doesn't pay any sum when due or perform any other obligation they're obligated to perform, the landlord can proceed directly against the guarantor. It doesn't say, but if the tenant has an argument that the rent obligation was suspended, then the following list of defenses is not waived and is vitiated. That's what would be required. It says nothing of the kind. In fact, it literally says the express opposite. It says in the next sentence, guarantor waives and relinquishes all rights and remedies accorded under applicable law to guarantors and agrees not to assert or take advantage of any such rights or remedies. Then there follows a non-exhaustive list of defenses that are expressly waived, which falls under that heading, waiver of defenses, including any defense that tenant's liability has ceased for any reason whatsoever. That's what it says. That's what the parties bargained for. I think where appellant goes astray, respectfully, is they cite a host of landlord-tenant cases which do, in fact, provide for various abatements or suspensions of rent for the tenant. But the guarantee cases are very different. And it's very clear, as in Chip, which this court decided was cited by the Supreme Court in the order below, said that guarantors can have greater and broader obligations than tenants.
But 80 also seems to say that as well.
Correct. In the Chip case, which Supreme Court cited, that's exactly what they say. I mean, it's literally what they say is that the guarantee and lease are separate undertakings, and the guarantor's obligations can be broader than a tenant's, and because the guarantee can be enforced without reservation or qualification. That's what was bargained for here.
So in other words, there could be a trial or maybe a motion for summary judgment, and the tenant could get, say, a 50% abatement, theoretically, for the conditions that have been alleged in the complaint. But your client would still recover the 100%.
Frankly, that's correct. The tenant may well have defenses that have been preserved that belong to the tenant. The guarantor does not have the defenses that were raised here. They were expressly waived. The defenses amount to the tenant's liability to pay rent, the tenant's obligation to pay rent, ceased and or became unenforceable because of the landlord's local law 11 construction work. And that is exactly the defense that was waived in sections 2, 5, and 8.
So how do you distinguish our cases like Moon 170 Mercer? Because there it appears that we found the failure of consideration of defense was available under a unconditional guarantee, right?
Right. My recollection of Moon is similar to the case that they cite, iBuilding Inc., where the guarantee at issue did not have a waiver of defenses. So the other thing I would say is that the argument regarding Section 19 of the lease is raised for the first time on appeal. And we say that in our brief, it fails for 3 reasons. Number one, you can't raise it for the first time on appeal. It literally was not mentioned or referenced below. Number 2, it's barred in any event by the waiver on sections 2, 5, and 8. And number 3, even if it could somehow circumvent the rule against raising it for the first time below, even if it could circumvent the waiver of defenses, it still failed to raise an issue of fact, which is the only salience it could have, if I may simply finish my statement, because they failed to submit any proof whatsoever to trigger the protections of Section 19 regarding the landlord's construction practices or the reasonableness or unreasonableness of the intrusions to tenants' business operations. And in fact, the only proof on those issues was offered by landlord in an affidavit from its construction consultant that said that landlord's practices were in accord with common construction practice, which is at page 318 of the record.
Thank you.
For those reasons, the order should be affirmed. Thank you, Your Honors.
Very briefly, judges.
No matter how you try to interpret this guarantee, the whole point of the guarantee seems to be to decouple the guarantor's obligations from the tenant's obligations.
Well, Judge, we know the guarantees are strictly construed, and we know they're particularly strictly construed in favor of guarantors who are not generally the authors of the guarantee. And I think it begs the question, what do we then do with this, what we believe to be condition precedent? What do we do with this language that is somewhat unusual, again, varying from Chip and varying from many others? You don't often see a guarantor guaranteeing against tenants' failure to pay rent when due, as opposed to tenants' rental obligations under the lease, or rental obligations, or some variation of that. And we think that's meaningful. And I would just add very quickly, this court, as I'm sure you all know, in Union City, I think it was Union City union suits, respected whether it's conditions precedent or exceptions at the beginning of a sentence or a provision. And I acknowledge that, but for that, this looks on its face like a pretty convincing waiver of defenses, unconditional, et cetera. But we can't make that preamble, we can't make that condition precedent go away, and it has meaning. I rest.
Thank you so much. Thank you both. Lee versus the City of New York. Whenever you're ready.
Good afternoon, Your Honors. Jimmy Wagner for the appellant, if it may please the court. I'd like to start by saying just recently,
What do you do with
Judge-
cases? What do you do with cases such as matter of Marstella and matter of Hogue?
so, Your Honor, each of those cases is an individual Article 78. Each of those cases required an individual attention to those Article 78s. To say that we have a collective ruling on individuals' religious accommodation requests, I think would fly in the face of the New York State Constitution. Every individual's religious request is required under New York.
But the requests were inadequate there, right? How is your request, based upon the principles enunciated in those cases, how is your request here sufficient to pass the test that those cases establish?
So when we say those cases established a test on the accommodation, I would say those cases deferred to bureaucrats. Judge Wilson just stated that it's the judges are entrusted with an important public responsibility, and bureaucrats shouldn't tell you how to decide your cases. Let's be very clear here. The record states that
So you're saying that the normal deference we give to administrative agencies in Article 78 is essentially no longer the law of New York?
no, Your Honor. What I'm saying is when there's a clear error of law in the record, when
What's the error of law in this case?
right, the error of law is found at page 357 by Eric Eichenholz. He's the city's expert on religious accommodations. He applied the federal de minimis standard when in fact...
Isn't that exactly what happened in the other cases that have been already mentioned, Hogue and matter of Marcellus?
That was one parcel. In both Hogue and in Marstella, this panel, the panel from the First Department, determined that the individual's religion wasn't sincere enough. They first agreed and aligned themselves with the lower court by saying you're not entitled.
I don't believe that that was what was stated. It wasn't that the religious beliefs were not sincere enough. We cannot make that determination. I think that the determination was that it did not fit within the construct of the provisions set forth by the city. But it wasn't that someone's religious beliefs were not sincere, that they were insincere.
Judge, I know you were on the Marstella panel. I was the
certainly-
attorney who argued it.
I know you were.
I sleep with that decision on my mind.
As do I.
Right, and I can tell you that it may have not have been intended to be written in a manner that questioned Mr. Marcella's sincerity. It reads, because we're talking two different rights here. We have a property right to employment, and then we have a constitutional right to the free exercise of religion. So if we're going to take away somebody's property right to employment, we now have to address why we're taking away their constitutional right to the free exercise of their religion. And in the lower agencies, and I understand during the pandemic, there was a lot of things happening, but this court is deferring to the agency themselves on matters of law. This is a Marbury versus Madison moment for this court, because you should never have to defer to agencies on matters of law. This was not an issue of how many people should be on the street.
Yeah, I don't know that we did, but Council, I have a question for you in terms of just logistics, right? So, if we did find that that this determination was arbitrary and capricious, right, which would be the standard?
Or an error of law.
Okay, but if we found that it was arbitrary and capricious and we send it back to the administrative agency or whomever, what is it that you would be looking for?
At that point, so New York City Human Rights lays out the procedure for determining an accommodation. We could speak to the accommodation.
But we no longer need an accommodation because the vaccine is no longer a requirement of employment. So that's why I'm a little unclear as to exactly what would occur. So what would happen?
Let's say
then?
when sua sponte happened, my client lost 9 months of accrued salary time.
Exactly.
So it's the 9 months is, I mean.
Okay, so that was my next question. Is there anything that precludes your client now from applying for and receiving the 9 months lost from accrued vacation time, whatever?
I'm not sure. I don't understand the question. He was denied it already. He used that time.
But can he not now apply? Is there not an administrative procedure for him to now apply to receive those monies?
No, there is no administrative procedure. In fact, to even make an attempt, they wanted these police officers and many other city
You
workers.
have to prevail here in order to begin to have a chance to get the 9 months credit.
That's correct, Judge.
Thank you. You have time on rebuttal. So the reason for I'm sorry, go ahead, you can introduce yourself. I
Rebecca
apologize.
Viscatus for the city respondents. May it please the court. Go ahead, Your Honor.
So the reason for that last question was I thought I saw something in your papers which opined that the plaintiff could in fact apply for and receive some type of administrative relief in terms of any monies that he actually lost.
I am not actually sure if there is a procedure that he could avail himself of for that, but I think that is not something that was specifically sought in the Article 78 proceeding here. The only reference to any monetary compensation was this sort of catch-all provision at the end of the petition.
If he prevailed in this proceeding, would he get the 9 months?
No, I don't think so. And I think even if Supreme Court had granted his petition in the first place, that was not relief that was specifically sought there.
Well, if nothing else, if there was a determination that what you had done was arbitrary and capricious, wouldn't it then follow that the city would follow the law, and that means that he had been terminated unlawfully, and that it would follow that the city should give him the 9 months?
Well, if he had been terminated, but the issue here is that this petitioner was never terminated. He made the decision to instead file for an early retirement and exhaust his leave time.
Yeah, granted what you say, but if he prevailed here, it would mean that he shouldn't have had to have made that decision. So it would mean that he should have been able to work those 9 months.
I think there's certainly some logical argument to that effect. However, the fact is that he used that leave time. He was paid for that leave time for time that he was not working. That was a calculated decision that he made under the circumstances at the time. Other employees in other agencies were terminated or chose not to avail themselves of those options and then were placed on leave without pay, but that's simply not what happened here. And in the Article 78 petition, there was no reference to how much leave time he used or what exactly he was seeking. There was no request to have that leave time restored or to be paid out for it, even though he was already paid for it since he was on paid leave during that time. And there was absolutely no reference to his other theory presented on appeal here that he is entitled to some hypothetical overtime pay for overtime hours that he could have
But
worked.
anyhow, your basic position is that the petition should be dismissed because the things that the appellant has stated in support of his religious accommodation claim have been found inadequate in Marstella and in Hogue.
Right. I mean, that's a reason for affirmance if this court does choose to reach the merits, which I don't believe is necessary since no accommodation is needed here. But if this court does reach the merits, then exactly under
Well, that
this
goes
court's-
to your mootness argument again, but I mean, the argument could be, hopefully, it won't occur. But if in the future there is another mandatory vaccine policy, then it would not be moot, right?
I mean, I think he would be making a new request for an accommodation at that point, and that would be considered on its own merits at the time based on whatever he put forth then and whatever requirement was in place then. But the idea that this accommodation request would somehow affect any future accommodation request is pure speculation at this
So
point.
I remember from Marcella, there was something in the record, and I do not recall whether there's anything here that, because counsel's certainly right, that each case should be viewed individually. Or is there anything in this record concerning whether the city had ever granted religious accommodation, a religious exemption, excuse me, for any police officers or detectives or other city employees?
I don't believe that there was information about that in the record here. However, I think that what is relevant to this court's consideration is whether the determination for this petitioner had a rational basis in the record, which, especially in light of the Marsteller decision, it clearly did. The same form with most of the same reasons was at issue in Marsteller, and very similar submissions based on the petitioner's moral belief that abortion was wrong and that receiving a vaccination would violate that belief. But for the same reasons that this court viewed as rational, affirmed as rational in Marsteller, those beliefs were not sufficiently connected to the petitioner's own religious views and religious practice. And here, in addition, I see my time is up, but I'll just finish this thought. In addition, this petitioner set forth reasoning based on potential side effects of vaccination that simply had no factual basis. And together, all of that gave NYPD and the citywide panel a rational basis to conclude that he did not demonstrate sincerely held religious beliefs that truly conflicted with vaccination here.
Thank you.
Thank you, Your Honor.
Just a couple of factual points.
Your adversary says that you did not make a claim for damages with respect to back pay and a compensation for earned time. Is she correct about that?
She's incorrect. The record, page 39, is just the wherefore clause. In the wherefore clause of the original petition, we request that any back pay, any monies lost due to adverse employment actions. That's number one. Number two, in reference.
Well, you don't specifically state that. You just say for further relief, I thought.
No, I just briefly looked at this record. It's definitely in my wherefore clause in the original underlying petition, and that's the record, page 39. Under each of the additional causes of action, I believe we request to be compensated for any damages suffered. In reference to your question, does the record reflect that anybody was approved? The record does reflect that people were approved in violation of New York State Constitution, and that's record page 267, where Mr. Michael Melikowski states he reviewed 6,500 applications. Well, 6,500 applications he denied. He granted 176 applications. We are never told what religion criteria these people had that they were granted this accommodation. New York State does not allow for a preference in determining religious accommodations. But the record here reflects that 176 people, which we don't know what the criteria was, because that was part of the underlying
Well, see,
process.
that's how I read that to mean that those individuals had met the criteria set forth by the citywide panel.
And let's talk about the criteria. The criteria is a generic word, Your Honor. We don't know what the criteria was. The criteria is never set forth anywhere. The only thing we know is that the wrong standard was used. We do know the wrong standard. Read the entire record. I've read this thing numerous times. The word criteria is never defined. And I'd just like to close with one quote, and this quote is actually from you, Justice Friedman, in the O'Reilly versus Board of Ed case. In your dissent, you said the pandemic may have necessitated excluding unvaccinated teachers from classrooms, but it did not somehow erase the precedent of the Court of Appeals addressing due process to which tenured teachers are entitled before they may be terminated. It's the same issue here. The pandemic was a terrible time. We got through it, but it doesn't erase long history. It doesn't erase our law. It doesn't erase precedent. And I would just ask this court to look to the error of law that the respondents admit in their own papers.
Thank you. Thank you both. Mazumdar versus the Board of Managers.
Good afternoon, Your Honors. May it please the court. I'm Ryan Capellas for the appellants. Points that deserve emphasis on this appeal are the context in which the provision at issue will not elect a majority of the board are located in Article 3, 1B. And starting with the first sentence read, after the earlier 5 years, or when the sponsor sells 90% of the units. The sale of 90% of the units would leave the sponsor with only 10%. The sentence goes on directly to the sponsor will relinquish the board, and the sponsor and sponsor designees will not elect a majority of the board.
So it doesn't say it says must relinquish control of the board, and if they have such control, and will not elect a majority of the Board of Managers. What's happened at the elections here? Do you agree that the sponsor has a continuing right to have one of the members of the board be an affiliate of the sponsor?
Yes, the sponsor.
Okay. Does the sponsor have a continuing right to vote at elections for members of the board, for all members of the board?
The sponsor does not have the right to be the deciding vote for a majority of the board. So the sponsor only has the right to be the deciding vote for
Where
three out
does
of the
it say
seven.
that he doesn't have a right to be the deciding vote for a majority of the board?
Because that is what it is to elect a majority of the board. It's not to unilaterally elect only if he
The
owns
other
more than
members of the-
50%. Even if he owns 10%, his vote cannot be the deciding vote to elect
Did
the
the
majority of
sponsor
the
have
board.
more than one member of the board, more than one of its affiliates on the board?
The sponsor can have
Did the
three-
sponsor have more than one of its affiliates on the board?
sponsor can have up to 3 affiliates on the board.
The other members of the board, after what you have here, is one group of unit holders against another group of unit holders. Some of them obviously are more favorable to the sponsor than the other, but they're not sponsor affiliates or controlled by the sponsor. It's just that the sponsor voted for them and put them over the top. But they're all just unit holders in that condominium.
Yes, that is correct. And if the provision in the bylaws which the sponsor drafted only included provisions relating to sponsor control, then the sponsor would be able to vote for all board members. But the sponsor also included provision which prohibited from electing a majority of the board, and it doesn't contain any caveats regarding whether the sponsors can elect
What does it mean
affiliated
electing?
voters or not.
What does it mean when it says they can't elect the majority of the board?
It means that the sponsor's vote cannot be the deciding vote for 4 out of 7 members of the board.
So then what is the sponsor to do? Not exercise his right to vote?
The sponsor is to not exercise his right to vote like it was held in the past cases, both First Department and Second Department, Flag, Realty Corp., TMN, Mondiah, where there are voting limitations on the sponsor's voting power as opposed to voting control. The sponsor is not to vote, or the sponsor's vote will not be counted if it is the deciding vote for more than a majority of the board. And again, the provisions in this paragraph.
That provision doesn't say what you're saying. Would you concede that? Maybe that's a reading of it, but that's not what it says.
Well, it doesn't say anything else. It doesn't say unilaterally vote. It doesn't say designate. And if you do read it in context, when it says.
We have to read it in context of the offering plan too, and the offering plan says specifically that each unit or owner, including the sponsor or its designee, is entitled to cast a vote.
Right,
Based
and
on its the amount.
right, and to that, and respondent's argument is that the offering plan and the bylaws, they are to be read together, but they are two separate documents. So you can provide for something in the offering plan, but then the sponsor chose to wrote how he was going to accomplish that, how that was going to be accomplished in the bylaws, and he went, it does accomplish that, and then it goes beyond and actually limits voting power. And the phrase may, even though the sponsor and sponsor designees may have the common interest, aggregate common interest, to enable them to do so, which is right after the will not elect sentence, it doesn't say the sponsor will not elect if the sponsor has enough common interest that enables him to do so. It says may enable him to do so. It still leaves the indication that this paragraph applies when the sponsor doesn't have enough common interest to designate or unilaterally elect. It has it in the first sentence, contemplating that it's applicable when the sponsor only owns 10%, and later in the paragraph.
What the offering plan says at page 484 of the record is that each unit owner, including the sponsor, has a right to vote and shall be entitled to vote, to one vote for each 0.001% of common interest attributable to its unit per member to be elected, and shall not have the right to accumulate its vote in favor of any one or more members to be elected. It doesn't say that it doesn't have a right to vote.
Well,
If its votes will lead to putting over a majority of the board, it's not what it says.
Well, every bylaw and every condominium says that the sponsor is entitled to vote, but the sponsor's vote is also, no one's arguing that the sponsor's vote is just unrestricted. It's either restricted if the sponsor owns 50% or more or can unilaterally designate. It's restricted if the sponsor hasn't paid common charges. And we're arguing that it's restricted based on the applicable language.
Thank you.
Nicholas Yanuzzi for the Board of Managers.
So did the sponsor elect a majority?
The sponsor casts one vote, the same as every unit owner. Votes are tabulated exactly as they are in any sort of.
Your adversary says that the sponsor's vote essentially put it over to the majority based on that vote.
The problem with my adversary's argument is it doesn't quite add up. It doesn't quite make sense because it's unclear how he's saying if the sponsor's vote were to be the majority vote or were to be the deciding vote, but it's unclear how that would even be done. Would the votes have to be tabulated first and then the sponsor gets to put his vote in? It doesn't say anything like that here. It says exactly as the court has seen in the offering plan, all unit owners, including the sponsor, is allowed to vote its percent of interest in the election. There's no qualifier on that. It is simply said they're allowed to vote the same as any unit owner.
And so which election are we talking about? What year?
The petition that was submitted in the motion court was about the 2021 election only.
And two prior elections went through with this procedure without objection by appellants.
Exactly. 2019, the sponsor was permitted to start to vote. It was allowed to vote in 2020, and actually there was no reason why the sponsor couldn't have voted before the 2019, except there was a conflict of arrears that was done, and the appellants didn't raise this issue. The appellants didn't raise it before 2019 because they had the issue of the arrears to keep this issue at bay. It's only now that the sponsor's been able to vote and the appellants can't get back on the board that now they're crying foul, and they're saying in 2021, after 2 years of the sponsor voting, that now this policy is unfair and is incorrect. The horse is already at the...
What does it mean on page 134 of the record, Article 3.1b, when it says, and will not elect a majority of the Board of Managers of the condominium, even though the aggregate percentage of common interest owned by them may enable them to otherwise do so. What does that mean, not elect?
The majority of the provision of Article 3.1b is about the transition of the sponsor giving up control of the board. It's talking about the process of once the sponsor gets to 60 units or more, is allowed to designate 3 members to the board. Once it's below 60 members, the sponsor is only allowed to designate a single member. If you'll look, the word is used elected, but it's actually that they're allowed to designate a member to the board. They're not casting votes for this member, they're appointing this member to the board. So this provision, this provision that the appellants are using is actually discussing the members that they're allowed to designate to the board. If you look at the end of section 1B, it does say, as the court has already pointed out, such owner's right to participate in the appointment of one member does not prevent the owner to participate in the election. It specifically says that right at the end of the provision. But the appellants need the court to focus only on this line: will not elect a majority of the Board of Managers. It's taken out of context and it's read in isolation. The appellants need the court to look at it just in this one line. You can't look at the offering plan that says all unit owners, including the sponsor. You can't look at the rest of the provision. The entirety of the appellant's argument is hooked onto this fraction of one sentence in a provision in the bylaws at the expense of everything else. The next part about it is exactly as we've already touched on. The appellants need the court to believe that simply by voting, the sponsor is electing members. This flies in the face of general reason because the sponsor has the right, as all unit owners, to cast one vote. And it doesn't equal electing a member. If there is a if a member...
The sponsor's voting for some residents over other residents.
The same as any unit owner, but that vote does not equate to putting the individual into the board. It also doesn't make that individual a member, affiliate of the sponsor. The sponsor is simply voting for people who are running. It could be any person running for the board, and according to the appellant, if the sponsor votes for them, then that makes it a sponsor representative, which is entirely untrue. The only thing that I would add here is there is a statute of limitations argument that wasn't directly addressed by the motion court, but deserves some attention by this court. Exactly as we've pointed out, the issue commenced in 2019. The appellants didn't raise it in 2019. This is in Article 78. They had 4 months to raise it from at least the election. They did not, and therefore the statute of limitations has ran on this matter.
Thank you.
Thank you.
So going back to Article 3, 1B, and the point raised by your adversary, at the end of that paragraph, this right to designate or elect, once the sponsor no longer owns any of the commercial units, the commercial unit owners or owners in the aggregate shall have the right to designate or elect at least one member to the Board of Managers. This right to designate or elect at least one member of the Board of Managers shall not limit such owners' rights to participate in the election of other members of the Board of Managers. Doesn't that, as to the other owners of commercial units, specifically give them the right to vote on all positions on the Board of Managers, whether it results in their electing a majority or not? And what you're suggesting is that this does not apply to the sponsor.
Yes, that is one of our primary arguments, is that in almost every portion of the offering plan and the bylaws, the sponsor is referred to separately from the commercial unit owners. The sponsor is never referred to as an owner. This provision...
But did you see in this the idea that the owners of the commercial units are going to have the right to vote for all members of the Board of Managers? They can designate one, as is the sponsor's position here, but as to the others, they can vote for all of them.
I agree with you, except that the commercial unit owners cannot designate one. What the bylaws in the offering plan say is that they elect one, they are entitled to elect it, so they're entitled to be the deciding vote. And
Yes.
then if that, the unit owners can remove that affiliated sponsor, either sponsor elected or commercial unit owner elected board member. And the offering plan and the bylaws provide that if that board member is removed, then the sponsor and the commercial unit owners get to then designate a replacement. And that's why there's the designation language in this paragraph. It's separate from elect.
Thank you. Thank you both.
Thank you, Your Honor.
So apparently we have students here from Baruch College. You guys are from Baruch? Well, welcome. Hopefully, and you're unaccompanied, right? You don't have a professor who's looking over your shoulder? No? Okay. But anyhow, welcome. Hopefully, you'll learn something. And if you have any questions, ask your professor. The next case for argument is Goldstein versus Kohler. So you see the students here, so behave yourselves, right? Act smart.
Good afternoon, Your Honors. My name is Christopher Cervigi, and I represent the appellant, Ms. Egerud. This is a very sad and disturbing case of a landlord bringing an Article 81 petition against its rent-control tenant, 93 years old, without family. And what happened is in order to separate Ms. Kohler from her friends and those that cared about her and her chosen power of attorney, my client, asserted various false allegations.
It's your position, actually, to get below the surface of it, that this was, I don't know if the word is instigated, but instigated by the owner of Ms. Kohler's apartment, who was a rent-controlled or rent-stabilized occupant, and if she's out, the apartment becomes worth major dollars more. And they instigate this guardianship proceeding, and I don't know whether you actually state it, but the idea is that so that they can get the apartment jacked up in value.
That is absolutely correct, Your Honor, and there is a lot of evidence that supports that. Namely, the false allegations that they asserted against my client were purportedly discovered, these alleged crimes, in 2019. If you read the affidavit closely, she goes on to say, the supporting affiant says, well, we don't have any direct evidence.
Because I know there's a lot of discussion of it when the court is ruling on this subject and the attorneys are arguing. And at the end, Ms. Egerbrud has trouble setting up a discharge plan when Ms. Kohler has to come out of the hospital. And what was going on that she was unable to set up a discharge plan?
I'm glad you asked that, Your Honor. First, I will answer that question, but I'd like to say very briefly that if everything the trial court said was true about the problems that evidently existed to exercise the discharge plan and so forth, the law still does not provide for setting aside the power of attorney.
Because at the time of the issue is whether at the time of the execution of the power of attorney, whether or not Ms. Kohler had the capacity to execute the document.
Right,
There was nothing in the record that suggested that she did not have that capacity.
Not only that, Your Honor, but there was substantial, that's correct, and the burden is upon them to prove that she lacked capacity. I'd like to answer.
Counsel, just one with corollary to that question is: was it shown that there was a breach of fiduciary? Was it shown that there was a breach of fiduciary duty, which would be a basis to vacate the appeal?
Not even close. Not only was there no proof of any breach of fiduciary duty, contrary to the false allegations of the petition, but it was proven that there wasn't. Even the trial court stated, we find no evidence of.
Well, that was financial. That was financial, but
No, in terms of the
service plan, what the cross petitioner was.
No, but I just wanted to be clear that in terms of her capacity at the time of execution, no issue as to that, and so the inquiry really should have stopped there unless there was an indication of some type of fraud or inability to.
That is the statutory language in the First Department case law.
Okay.
Not only was there no evidence of incapacity, but there was substantial evidence that she had absolute capacity to do what she did. The attorneys at issue took extra care. To answer your question.
I want to take you back to that because
Yeah,
I understand that what you say is the law. I'm not disagreeing. But
I'm happy to answer it.
And I'm not suggesting to you that the question I ask you is outcome determinative of the appeal, but I just wanted to understand that issue better.
Okay, fair question. And the answer is, at the time of there was a temporary guardian appointed at the time. So she had no power to exercise any discharge plan. I mean, prior, when she was in the hospital, by the way, the landlord waited until she was in the hospital and incapacitated to serve this petition. So so they get the Article 81 petition. The temporary guardian was supposed to be the one that executed the discharge plan. She was precluded from doing that.
Was she allowed access at all to Ms. Kohler?
Well, they quickly moved to separate her from Ms. Kohler by these false allegations of crimes, which the trial court had no basis to know or not know. So she said, "Yeah, I'm going to separate you all from Ms. Kohler." So she had no way to really. There were times when she did see her, Your Honor, but under the
But
supervision.
your client had also stated that she couldn't do a discharge plan, or she didn't do one because she had been informed by one of the doctors or someone there that Ms. Kohler was hallucinating or something, or was not
No,
able to.
she was sick at the time. I mean, she had COVID and pneumonia. And by the way, she did exercise a discharge plan to the extent that she could. It's in the record and it's in my papers. She did try to do what she could without any powers.
The healthcare proxy was paused as well at that.
Yes.
So really,
Yes.
could she be involved with any medical issues
No,
with
no.
doctors?
That was the temporary guardian's job to do that. And she did the best she could. She tried harder than anybody would have done to visit her, to try to see her, to do the best she could. She took care of her to the best of her extent, but then she was precluded even from entering the apartment, which, by the way, Your Honor, the landlord, and this will, the landlord locked her out. In fact, it changed the locks, an illegal lockout. She couldn't even get in to get Ms. Kohler's clothes for her. She was precluded from doing anything. And for the trial court to say that, it was, it was just error. It was factual error, and it meant nothing, even if it was true, because, as Your Honor pointed out, the Article 81 provides that they can only set aside a power of attorney if there's malfeasance, of which the trial court said there was none, or if there was lack of capacity at the time of executing the document, of which not only was there none, and they didn't even try to prove, but there was substantial evidence that she did have it. 3 attorneys were there when she signed those papers and took extraordinary measures to make sure she knew what she was doing, that she was competent, and that she wanted to do what she did.
Thank you.
None of that was questioned. Thank you.
Good afternoon, Your Honors. Elizabeth Adenolfi for Respondent, West End 48 Units, LLC.
So, counsel, where in the record does it, one, establish that Ms. Kohler lacked the capacity at the time of the execution of the power of attorney?
At the time that we had the trial, we had conceded that she did not. We offered to stipulate to that so we could cut the hearing short.
Excellent.
Stop
So
raising
now
the
we
fees.
move on to where in the record is there any showing of malfeasance or anything else, inability on the part of the defendant to perform her duties?
I think it's replete, Your Honor. Justice Sharp made the determination that Ms. Egerud was fundamentally dishonest.
But the question was, where in the record is that shown?
If we can go to all of the testimony regarding the lack of an FBI investigation.
The lack of an FBI investigation, is that what you're saying?
Yes, Ms. Egerud kept insisting for months and months and months that there was no FBI investigation.
But where is the proof that she somehow committed some type of malfeasance, that she took any money that belonged to Ms. Kohler?
She did not. The court made the determination that she did not engage in financial malfeasance.
So then
Okay.
what's the basis to grant the very, very drastic relief of striking a power of attorney where clearly the AIP had capacity at the time she entered into it?
The court found that Ms. Egerud.
Okay, so let's stop for 1 second. Where in the record, not what the court found, okay, but where in the record does it state this?
Well, in her decision, Justice Sharp
Back
says.
to the, okay. Not in her decision, not what she said, but in the actual, record, like the record?
Like the proof.
Where in the record is there a showing that there was malfeasance?
There was dishonesty. There was violation of court orders, and I will point to.
These are all conclusory statements.
No, they're not.
How do you justify, you act based upon the fact that the accountant, who's a member of the board, says that the financial irregularities And Ms. Gentile noticed those irregularities in 2019. You don't file the petition, your client doesn't file the petition until March 4th, 2022. And then you concede when asked about it that you did it only because you were afraid that you were going to be sued for having interfered, for not honoring the power of attorney.
We did not know, Ms. Gentile is a member of the board. That's a separate entity than my client. My client did not know any of this until this issue of
But
power
it's
of
your
attorney
client
came
to
up.
act.
Your client knew that Ms. Gentile was the treasurer of the board, correct?
She knew she was the treasurer of the board, but she didn't have the knowledge. They're not related corporate entities. They're separate corporate entities. There's been a lot of confusion of that.
But it's your client who starts this on the way.
Yes, finding out that there was the FBI had come to the building investigating potential financial abuse.
When was that?
That was in November of 2021. My client didn't find out about that until February, when we're being demanded to give this woman access. We find out that
Who is this woman?
Ms. Egerud is demanding to be given access. We actually asked for an affidavit of full force and effect for the power of attorney, and they refused to provide one. We learned that the FBI had come to the building.
And did you learn that the FBI came to the building because Ms. Gentile had filed a complaint with the FBI?
That's not what happened. The FBI came to the building. Ms. Gentile's testimony is clear. When she found out that the FBI came to the building, she contacted the...
How much was involved that caused this FBI involvement? How much money was involved?
I don't know what caused the FBI
Was it
involvement.
$50,000 or some
No, it was
allegation?
more like $180,000. No one knows. The FBI has never told us.
So is that typical for the FBI to come in and investigate that sort of a discrepancy in someone's
You would think they
account?
had better things to do.
I don't know what the FBI knew that started the investigation.
Okay, so we have the FBI investigation, which ultimately was not founded, or nothing came of that.
It didn't bring charges.
It didn't bring charges. So what else is there in record in terms of, assuming that constitutes malfeasance on the part of Ms. Anker, what else is there?
There is the dishonesty. There is the disobedience of...
What dishonesty?
Let me get to the section where I have in my notes where I pointed to several things in the record where dishonesty about the discharge, what happened about discharging her from...
Excuse me, at the time all this occurred, wasn't Ms. Kohler convalescing in a nursing home? And wasn't she subject to essentially a restraining order preventing her from acting in any of the ways that the court points out were the bases, I guess, of why the power of attorney was vacated?
Not at this point in time. If you read the social worker, Mr. de Guzman's testimony, he told Ms. Egerud that discharge planning should start in January, I believe. Ms. Egerud then claims that no one ever told her that Ms. Kohler needed to be discharged.
And that's a breach of fiduciary duty, is what you're claiming?
No, they're claiming that's dishonesty.
I think a fiduciary has to uphold the highest standards of honesty. This is black letter case law.
So Ms. Goldfein is going to uphold the higher standards of honesty with respect to Ms. Kohler. Is that your argument?
We're not the guardian.
Yeah, you are the landlord. You're the building owner.
We brought this because there was concern, there were red flags that someone was
You
being
brought a
exploited.
petition. You brought a petition which we're dealing with, Ms. Kohler, who had approximately $800,000 to her name. You started a guardianship proceeding which ends up with all sorts of fees being paid out of $800,000, and then $14,000 a week for home health care. So that one has to imagine that at this point, that money must be gone completely or almost gone completely.
One point about the fees, there's a claim that the court evaluator was paid $78,000. If you look at Justice Sharp's order, he received
Someone else was paid
$7,900.
$22,000, and at the end, you've got home health aides coming in at $14,000 a week for someone who had, at the start of this, approximately only $800,000 to her name. We're not talking about someone who has hundreds of millions of dollars and can afford that sort of pricey health care, her money would have been gone in no time if this remained in effect.
Justice Sharp was clear that her funds, Ms. Kohler's funds, were to be used for her care. She required 24/7 care.
$14,000 a week.
That's what it costs to get 24/7 care. And in fact, Ms.
What efforts
Egerud,
were made to find a cheaper alternative?
I'm sorry, I didn't.
What efforts were made to find a more reasonable alternative to the
That's the
home care?
Guardian, that's the Guardian's choice. Justice Sharp did not, that wasn't our decision who her home health care aide was to
So
be.
ultimately, speaking for myself, it looks like a situation where the landlord comes in, brings a proceeding, all the AIPs, or at this point, I guess, an IP, the monies are used up, and she's going to be forced into a nursing home. Now, I don't know how that squares with her due process rights, and frankly, the law under the circumstances, given that there was a valid power of attorney.
As far as whether she ends up in a nursing home, she requires a certain level of
Who
care.
benefits from her ending up in the nursing home?
Not my client.
Party who brought
There is case law in New York County that even if a rent-controlled tenant goes into a nursing home, the landlord does not get the right to reclaim the apartment. That was never a part of the agenda. Justice Sharp even said she found that that was not a credible claim.
So who gets the apartment?
She'll continue to pay rent until she passes.
Who's paying the
Who's
rent?
paying the rent?
Right now, the Guardian is paying the rent.
Until we deplete the monies, right? Until all the monies are depleted, right?
The money is being spent on her care. If she wasn't receiving 24/7 care in her home, she'd have to be in a nursing home. The point was to give her the care, the quality care, and in fact, the August proceeding that Mr. Serby brought up in his reply papers, Ms. Kohler was doing very well because of the quality of care that the aides were providing. She was doing quite well.
So I just want to back up 1 second, and I recognize you're out of time. I just want to be clear now. So the landlord, your client brings the proceedings because the FBI comes to the building?
The FBI came to the building. We had information that money was missing from her accounts. We had information that Ms. Egerud was isolating and separating Mrs. Kohler from other people. She was taking videotapes. Ms. Gentili testified to this, videotaping her, asking her leading questions to say that she didn't want to see anybody. That kind of isolation is a very big red flag when we're talking about the elderly people who don't have family. We knew that there were transactions that Mrs. Kohler had no recollection of making or what she did with the money.
What was the landlord's relationship with Ms. Kohler?
She's been the tenant for 15 years.
Are they friends?
I wouldn't say that they were friends, but Mrs. Kohler is someone who's very beloved in the building. There was a concern that she was being exploited. My client...
Were repairs being made in the apartment?
Excuse me?
Were repairs being made in the apartment before these proceedings got started?
My client did not receive requests for repairs to be made to the apartment. Once again, the different entities...
Was it correct that the super turned off the gas to the stove? Because there was a complaint about that?
I do believe the gas had been turned off.
So rent-controlled or rent-stabilized apartment, did the landlord come in and replace the stove, knowing that the elderly woman had no gas to cook on?
She did not ask us to.
Who's she?
Mrs. Kohler.
You said that Mrs. Kohler had been there for 50 years, not 15.
No, I believe that my client owned it for 15 years, so she's known her for about that long.
Okay.
This was not about getting her out of the apartment. This was about making sure that she wasn't being exploited.
Oh, by the way, I wanted to ask also, I didn't see anything in the record, but was there any type of complaint made to the Elder Abuse Division of the Manhattan District Attorney's Office?
We discussed that with the FBI, and I believe that he had discussions with the DA's office.
Okay, thank you.
Did anyone call Adult Protective Services?
That was, yeah.
I don't believe anyone did. They're not always the most helpful. But
No.
I would like to say, we were not trying to protect ourselves from a lawsuit in general. There was a power of attorney. We didn't
It is
want
what
to
the
honor
evidence
it.
shows, though. I mean, there is testimony, I should say, there is unequivocal testimony to that effect.
We didn't want to resort to self-help and just ignore this power of attorney. We went to the court that had the ability to investigate and determine whether or not Mrs. Kohler was at risk of being exploited. And if the court found she wasn't, it would be over.
And you waited almost 3 years to do it.
We didn't know it until February of 2021. Ms. Gentili's knowledge is not my client's
So
knowledge.
did Ms. Gentili tell you why she did nothing about this in 2019? Why she allowed 3 years to go by if she thought there was exploitation going on?
She testified that in the first instance, Mrs. Kohler got very upset when she asked her about it. She didn't want to pry. The next time that she had concerns, Ms. Egerud was present, and she didn't want to have that discussion with her then. She did inform Ms. Egerud at one point, the money might be missing, please go to the bank and see if you can find out what happened. And Ms. Egerud says she just ignored that. And she also ignored when the FBI contacted her about the fact that Mrs. Kohler was possibly being financially exploited.
Thank
She took
you.
no action.
Yes, Counsel, you have time on rebuttal.
Your Honors, the reason sanctions are appropriate is because there's been a number of false representations made, even now, not only in the opposition brief, but even now. One, we had info that money was missing from Ms. Kohler.
Counselor, when did you first make a request for sanctions?
Down below, I was not involved at the trial. Counsel did make a request for attorney's fees at the trial level, and I'm making a request for sanctions.
Counsel, does Section 130 of the rules of the courts provide that you walk in and ask for sanctions? Isn't there a requirement that you make a motion for it so that the opposition has a studied chance to respond to it?
And I understand that, and that is why I was careful in my brief to say the request for sanctions we're making are false statements to this court. And the false statements that were just made.
But even that comes in your reply brief, which leaves the opposition without an opportunity to
I know, but
respond to
I don't
that.
know what she's going to say until she says it. I mean, in the opposition brief, there were false statements made. Just now, there were false statements made. Just let me say one of them is that the money was, that we had information money was missing from her account. What the supporting affidavit actually says is that Ms. Gentile investigated that issue, and Chase cleared it up, that there was an audio tape of Ms. Kohler transferring the money to herself. They knew going into this that there was no money missing from the account. They knew going into this. So for her to say to this court just now that we had trying to justify what they did by saying there was money missing from their account, no. They knew that it was not missing from
Well,
her.
as they stated, Ms. Gentile and the landlord or the owners are
She's the
different
treasurer of the
entities.
board. You know,
But they're different entities.
Yeah, but she submitted the supporting affidavit in connection with the petition. Obviously, she would have had to read it. I don't mean to say obviously. So she read, I mean, the counsel of the landlord submitted that petition to the court with a supporting affidavit that exonerated Ms. Kohler, Ms. Egerud, and showed that the funds were not missing, that Ms. Kohler transferred it herself. And yet she comes before this court just now and says, we had information money was missing. She had information money was not missing, not that it was missing. And there's a number of other false statements that there were numerous requests we made for the repair of the apartment. Those are in my papers. I asked the court to look at it.
When was the gas turned off?
When was it?
You know what year that was? Was that between 2019, 2020?
I don't know the exact year the gas was turned off, Your Honor. The power of attorney was submitted 3 different times to them. That's also in my papers. The FBI
Well, they
investigated.
stated that when your client asked for access to the apartment, that they asked for a copy, and she refused to comply.
Well, she made, but her attorney at the time provided the power of attorney. I provided the power of attorney. It was provided on three. Those are in my reply papers. So they did know that there was a power of attorney. The suggestion that it wasn't provided to them is just simply false. And it's an attempt to justify this petition. Now, the last thing I want to say, I know I'm out of time. You know, Ms. Kohler is going to be 94 soon. She is sick. Your honors were exactly right, everything you said. Of course it's to get the apartment, and they will get the apartment. She has no family. She has nobody living there. And so she does ask for expedited relief so that she can spend the final years of her life with her money back, hopefully, and in her own place. She's under the arm of a guardian now, and very unhappy, and it's a very disturbing.
What monies do you believe she's entitled to if we were to agree with your position?
The court can and should put her back into a place where she was before this started, with her monies returned, and certainly for all the fees paid.
What do you suggest we could do about the $14,000 a week, which has been spent on home health?
Well, this is why I asked for a hearing on these issues. That there should be a separate hearing on what the waste was, what was improperly spent, because your Honor's instincts were absolutely right. Of course it's ridiculous, $14,000 a week. She was doing fine before this, by the way. She was almost ready to go home. Part of the problem is that the guardianship process did expedite her sickness and did make her very unhappy and continue to make her ill. So what the court can do, number one, is to overturn this decision. Of course, that is the first step. The second step is sanctions for false statements before this court, because there were numerous identified just now and also in my reply brief. And thirdly, to the extent you can order sanctions from what happened below because trial counsel didn't make it, there should be a hearing on these issues of why so much money was spent. This guardianship is often, not always, but is often is just a...
But the money spent on care was the guardian, not the petitioner bringing the Article 81. Why would that be their responsibility?
Well, the law provides that the fees of the guardian and all that should, in the cases like this, where there's...
fees are different. Fees are different. We're talking about the expenses only, the $14,000 a week.
Well, if there was waste, then somebody should be held accounted for that. It shouldn't be Ms. Kohler. It shouldn't come out of her funds. It should come out of landlord's funds for a petition that never should have been brought. They knew when they brought this petition that there was no basis for it, and they repeatedly misrepresented facts to the court, to put it bluntly. And so the court is empowered, has the same authority as the trial court does, and it can order her to be put back in the same position it was. I cited that case in my papers, that this court has as much authority as the trial court. It can order that petitioner put Ms. Kohler back to where she was.
Thank you.
Yep.
Thank you very much.
Thank you very much, Your Honor.
People v. Raymond Castro. I'm sorry, that's submitted. Rosenthal v. Sperling.
May it please the court, Eric Leiter of Morrow Lillington Party, for appellants Dr. Danny Sperling and his practice, Sperling Radiology, PC. Of the 3 items of relief that the appellants seek, I'd like to begin by discussing why it was insufficient for the court to grant a mistrial as to only a portion of the trial rather than the entire trial. It's our contention that when it is apparent to a trial judge that a burden of proof charge was missing, that errors in...
Counsel, how do we make of what you said in your reply papers below, that you're not seeking any relief regarding the errors at trial? So how is that preserved for us to even consider?
Well, there are two pieces that answer that. I think first, the court, after the filing of the motion, specifically requested briefing on particular issues, including the summation made by plaintiff's counsel and its failure to give a burden of proof charge. And so what we did argue in our papers directly was that we asked the court to either resume the proceedings or to declare a mistrial. And we noted in the papers that if the court was refraining from declaring a mistrial at that moment because it presumed that it was going to fix the errors later, that was an unwarranted supposition given the facts.
Didn't you subsequently make a motion for a mistrial?
No, Your Honor. This is
the only motion you made?
There is a motion, there's a post-trial motion separately that was decided by the court, and that's the order that
On July 17, 2020, you didn't file a motion for a mistrial as the entire trial?
That is the motion. That's the motion that led to this appeal. So there were 2 mistrial applications made during the trial that the court left unresolved in 2019. And in 2020, when there was no stay prohibiting the court from going forward and repeated requests that the court resume went disregarded, we filed a motion on notice. At that point, we asked the court to either resume the proceedings or declare a mistrial. And that's the the order that the court issued a year later in 2021, deciding that motion in 2020, that mentioned that 2 mistrial motions made during the trial in 2019 had yet to be addressed, is the order that leads to this appeal here. When the court denied a mistrial as to the entire trial, it knew from the papers in front of it and the record that it had failed to give a required burden of proof charge, which could not be harmless, that it had failed to poll the jury, notwithstanding the request for a polling of the jury, and the case law holding that that cannot be a harmless error. This case is readily distinguishable from any one that the plaintiff would cite where the court was not required to conduct the polling because it was waived, because the cases that they would cite there are when there's a unified trial, where the court had an understanding that the request had been withdrawn and that the defendant no longer wanted polling, and then the judge in front of the attorneys dismissed the jury with no objection being made by the party, insisting that they wanted polling. Here, the defendants were clear time and time again that they wanted the polling. The judge knew that. The jury was still impaneled. This was a bifurcated trial, and they just never received the polling. That reason alone would entitle them to a new trial.
But right after, didn't you not ask for polling?
So on the 19th, as the problem being that because the courthouse was closing down and the judge had made clear that she wanted to be gone by 5 o'clock that day, as the courthouse was closing down, the judge made sort of a quick reference of asking, do you want polling? And in that moment, in those circumstances, the attorney said no, but followed up with a written request for polling 15 hours later approximately, before 9 a.m. the next morning, and under the holding in Pickering, it's clear that that was proper and that there was not an irrevocable waiver of the right to polling.
But by then, hadn't the jury already been discharged?
No, they had been released for the day, but they were coming back because this was a bifurcated trial. The reason and they did return, they returned on December 11th. The reason the polling wasn't done on December 11th, though, was because of the plaintiff's application for an unwarranted, unlawful order seizing the defendant's assets that forced the defendants into bankruptcy. And because of that bankruptcy, there was now a stay. And so when the jury came in on December 11th, the same jury that had returned that verdict and otherwise could have been polled, they could not actually poll them on that specific day because of the bankruptcy stay. And when we sought to have...
So you caused it. Your client caused that issue by seeking a stay of the proceedings in bankruptcy court, right?
No,
It's
Your
an
Honor.
automatic stay, but that's what happened.
No, Your Honor, and as the bankruptcy court addressed, the bankruptcy filing was necessitated by the order that the plaintiffs obtained that was an unlawful order. They never should have been issued...
Wait. Who moved for the bankruptcy stay? Was that not your client?
Bankruptcy stay was automatic. It operated by operation of law upon the filing. And the court knew that once the order that it had said it was issuing became an entered order, there would be a bankruptcy filing. The bankruptcy attorney had even come to court before Judge Tewitt and made that clear.
So I'm not understanding. There's a stay of the proceedings now, so how do we poll the jury?
Well, the problem is since then, the judge has discharged the jury without polling them. The fact that there was a polling request that ultimately led to the
If
court...
there's a stay, could the judge have then polled the jury? There's a stay of the proceedings. Does a stay not mean no further proceedings? Nothing else should be done?
At that moment, but the stay was lifted. And when the stay was lifted, the court still did not poll the jury.
Was the jury still present when the stay was lifted?
The jury was still impaneled, yes. The jury remained impaneled for approximately a year and a half after the stay was lifted, and still there was no polling of the jury, despite repeated requests from the defendant and with the court understanding throughout that time that the defendant still wanted the jury polled.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Jonathan Dax, representing the plaintiff's respondents.
Counsel, I'm confused. Did your adversary, in their reply papers at least, limit what they were, the scope of what they were seeking?
Oh, 100%. Never have the terms as limited by the appeal, by their brief had more bearing than in this case. They limited it severely. They said specifically numerous times, and I can go through it, but I don't think you need to hear my summary. It's not enough. We don't have enough time for that. But numerous times they said the only issues that we're seeking a mistrial on do not have anything to do with anything that happened during the trial. That means the alleged misdeeds of the court, mistakes by the court, the alleged misdeeds of the plaintiff's counsel. None of that has anything to do with this. The issue of polling shouldn't have even been discussed now because that was also not part of that motion and should not, and is not part of this appeal by their own
The motion
statement.
filed was a motion for a mistrial as to the entire trial, and then goes on to limit it. Well, if not that, then with respect to at least.
Right, and they did benefit from one aspect of it when the judge, out of an abundance of caution with regard to the charge on punitive damages, ruled in their favor and set punitive damages aside, both the issue of whether there's an entitlement to punitive damages and the amount of punitive damages. So what you have here is they are, by their own doing, limiting the appeal dramatically, and none of these other issues, polling included, and any other ones, all the arguments and points about counsel's misstatements, alleged misstatements and misbehavior during summation have nothing to do with this appeal. There is another appeal down the pike on a second order of the court, which ruled against the defendants in every manner. And I assume they're trying to hold off all those issues for that appeal. But this appeal is extremely narrow and proscribed. And on that point, the one point that remained is, was it impossible for this for the court to get the case going and to have the trial continue in phase 2? Counsel said it's a bifurcated trial. We had 2 phases. I think the court is familiar. Phase 1 was complete. It went all the way through almost 3-month trial and a jury verdict.
So I have another question with respect to the restraining order. Didn't you stipulate to vacate that?
Yes, so
So aren't you bound, just if
I'm
we were
giving
to
it.
hold
I'm
it-
giving it to them. We can cut that out completely. I don't think there needs to be another order. I think we have the stipulation. I think we have their comments that I quoted in the brief about how, as a result of the bankruptcy and the transfer of assets, there's no point, there's no validity, there's no reason for the vacator of that order. But if that's what they want and need for some reason, as long as they are not going to come back and tell you on rebuttal that if I say there should be a vacator of that order, I've somehow conceded the arguments they made, which are bogus arguments about how my clients did something improper to obtain that order, then give them the order. We can vacate it. Nothing will change. I predicted that in my brief. I'm happy to argue that that shouldn't happen. I'm just as happy to say, let's get that out of the way. The court doesn't have to deal with it. There's too much he said, she said, that I'm sure you have no interest in hearing at this point. The third point, and the last point that I'll address, is with respect to the issue of sanctions, which counsel has not yet spoken on. I handed up and provided to counsel a copy of a recent Second Department case, just because it's recent. There's nothing earth-shattering in here except there's good language, which is consistent with the language of the cases that I cited from this Court of Appeals and this court, which is the decision of whether to award sanctions and the amount or nature of those sanctions is generally entrusted to the trial court's sound discretion. What you had here was a very long and contentious trial. There was a lot going on. The judge was in total control. She made rulings. She made corrective comments to the jury. They also limited their appeal here as well. They're kind of hoist on their own petard. But they argued that the sanctions were addressed to frivolous conduct by making false representations of fact and law, and nothing else. So any other type of issue that they're going to raise is not appropriate, again. But as I said in my brief, it's good language, and I'm going to use it again. Aside from the fact that they had very unclean hands, and I see I'm out of time. The judge saw it all, dealt with 2 difficult lawyers. I concede my client's lawyer was difficult, but so was theirs. She saw it all, she heard it all, she took it all in context. She said she likes to let lawyers try their case. She kept her eye on the ball. And there was nothing more than zealous advocacy. And what I said in my brief, and I'd like to repeat, is defendant conflates innocent failed recollections or confusion with guilty prevarication. That's my own language.
Thank you.
Okay, thank you.
Thank you, Your Honors. To begin with the issue of sanctions, the plaintiff's counsel deliberately misrepresented to the trial court that there was no order issued by Justice Capella denying a motion he made to amend his pleadings, when in fact there was one and he was served with it. It caused the trial judge to ignore the law of the case doctrine and permit new issues into the case that Judge Capella had ruled were not to be permitted. The attorney also claimed to have an order that was claiming it's a federal court decision determining for the entire country certain issues in the case. No such order exists. What he presented was a magistrate's recommendation that was never accepted by a judge and had no bearing on the case. It caused the court to accept that as determinative. It tainted and poisoned the trial. He misrepresented the defendant's assets to obtain the seizure of their assets in the restraining order. He misrepresented whether he had filed the application with the ex parte part and whether it was accepted. The various actions that they undertook that we identified that are undisputed. He doesn't deny at this point that he did everything that we identified. Clearly warrant the imposition of sanctions. And on the issue of the procedure of the case or the posture of the appeal, I note first that in the interest of judicial economy, it would be prudent with all of the issues before this court, having already been before the trial court when it decided the motion and issued its order, and said that it was denying all relief that it had not granted for all motions and all applications up until that time, that it would be proper for this court to address it here, and also note that this court had previously issued an order on this appeal when it was disputed as to whether or not the issues were properly before this court, whether this was procedurally proper, and whether it could be heard. And in light of that, I would ask this court, again, if for no other reason than in the interest of judicial economy, to address the issues that are before it with the proof that is clear that the defendants were deprived of a fair trial.
Thank you. Thank you both. So counsel, we're aware of what's going on, but thank you for your input. Capitas Servicing versus MS Health. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, Charles Kleiner of counsel to Robert Harmon, Esquire, counsel for the defendant appellant. I'll be brief, Your Honor, Your Honors. Really, there are two issues before the court that the court's been briefed on. If I may just reiterate, we have an IAS court that committed reversible error by allowing an entity to proceed with a lawsuit through its agent when the agent didn't have the capacity to sue.
Did Capitas have a monetary interest in its agreement with TVT?
I'm sorry?
Was there a monetary interest? Doesn't Capitas have a beneficial monetary interest?
It gets paid to service the.
Oh, the answer is yes to that question?
The answer is yes.
So doesn't our case law say, or doesn't the case law say that because it had a monetary interest, therefore it can sue in its own name?
Not monetary interest in terms of the lawsuit. It gets paid to service the loan. The proceeds, as a servicing agent, go to the principal.
Won't what they receive be affected by what happens in the lawsuit?
I'm sorry, Your Honor?
Won't what they receive be affected by what happens in this lawsuit?
Unless they're paid on a percentage of what they collect, they're a servicing agent. So they, as far as I know, and it was never on the record, that their compensation.
If they prevail on this lawsuit, there'll be more collections and they'll get paid more.
Theoretically so, they obviously if they do prevail, but again, it can also be a subterfuge where they're bringing lawsuits on behalf of a principal that doesn't have the capacity to bring the lawsuit. They were.
Isn't there an agreement in place here? So I don't understand. So should we just ignore the agreement that the Capitas has with TVT?
Not that they should ignore. There are states where they don't have the requirement that we're raising. Had this been brought in New Jersey, had this been brought in Pennsylvania that doesn't have a publication
Right, but
requirement.
unfortunately, it was brought in New York.
It was brought in New York
So
because
unfortunately, we have to address it. So the issue is in New York because they do have an interest, and as was stated, you know, if they are successful, the more they're going to receive. Our case law, is it not that they would therefore be able to sue in their own name?
They can't sue in their own name. They're not, this was a factoring agreement between TVT and MS Health. TVT hires a servicing a company to service their loans, okay? These purchases of receivables.
But you just acknowledged when we started this argument that Capitas has a beneficial monetary interest, and that sounds like what you're saying by that acknowledgement, that Capitas is the real party in interest here.
No, they're not. They're not, Capitas, if Capitas was successful, again, they were not named as the plaintiff here as an individual entity. They were named as the servicing agent, just like you have mortgages that are serviced by independent companies. The independent companies are not the companies that will foreclose, will not receive any proceeds from a foreclosure sale. Capitas will not receive, well, unless they have some type of commission agreement, they won't receive anything outside of their agreement with TVT, whether they're successful or not.
This is Capitas's duty to do under its agreement with TVT, is it not?
To bring lawsuits. At the time my client entered into the agreement with TVT, it was not Capitas's, was not granted the authority to bring lawsuits.
Capitas is now taken over to service TVT.
Servicing their,
And Capitas does have authority to sue in New York.
after the fact. At the time this action was brought, at the time this motion was heard by the AA's court, it did not have the authority. It couldn't have had the authority because its principal didn't have the authority.
When did Capitas's authorities to sue in New York start?
And, well, apparently they had signed, they had a new agreement with TVT in, I believe it was 2019.
Capitas independently has authority to sue in New York, does it not?
If it was its asset, yeah. This isn't Capitas's asset, though. The receivable that was funded by TVT is TVT's
Why
asset.
doesn't it even have to be their asset? Their job is to see that these loans get paid or that what's collected gets collected. So they've got authority to sue in New York. They've got jurisdiction over your client. Why can't they bring that action in New York?
Capitas would be if it was Capitas's asset to bring. Had this been an assignment.
But it's Capitas's
was no
duty
assignment,
to
Your Honor.
collect these funds.
As an agent, correct.
Yeah.
As a collection agent. We have collection agencies that do that in everyday commerce, Your Honor. It's their job to collect it as an agent
And
for
turn
their
over,
principal.
so it's your position that's their job to collect it as an agent and turn over everything to TVT.
Correct, subject to whatever agreement they have with TVT.
But that's the rub. Isn't that the rub? It's a revenue-based servicing agreement, and Capitas is entitled to monies from that.
We don't know. That wasn't before the judge, before the IIS court. There was nothing on the record to indicate that they had a financial interest in bringing this action. And had they did, they would have been named as a co-plaintiff, for example. They're not named as a co-plaintiff as an individual entity. They're named as the servicing agent. For example, let's say TVT never purchased a receivable from MS. Would Capitas have the independent right to sue MS? No. They didn't provide any
You
consideration.
have time on rebuttal, counsel.
Thank you.
Yes, counsel, I hope you were texting for some guidance. That's why you were sitting there texting. Guidance in responding to the arguments by your adversary.
Good afternoon, Your Honors. First of all, I wanted to make sure that we clarified a couple of things. We did not provide a loan. We purchased future receivables from.
Well, I was going to say that, but we kind of glossed over it because there was an issue as to whether there was a loan or whether you characterize it as a loan or not.
Oh, so we're going to go to the.
I think we characterize it just that way, just as a matter of convenience.
Yes.
Certainly. certainly it's a bit of a distinction in the financial services industry, but I absolutely understand. In this particular case, Capitus has the ability to file suit in the state of New York. We have a monetary interest in this particular matter. We not only we did service this particular financial transaction.
What is your monetary interest in the contract?
We serviced the transaction, and in addition, we funded a portion of this particular
So
contract.
you purchased a portion of the
Yes.
accounts receivable, about $89,000, as I recall, is that correct?
Yes, we purchased about $60,000, and the damages requested is approximately $81,000.
So you do benefit, you benefit from, there's a monetary benefit from the transaction?
For us, yes.
And is that borne out in the record?
Yes, Your Honors.
Because your adversary had stated that it was not.
Yes, I was a bit confused.
So what in the record shows
Oh, you were
that?
texting.
It would be in the agreement that MS Health signed with TVT and with Colonial.
What in the record shows that you're pursuing your independent interest also?
There's an acknowledgement at the bottom of page 5 of the original funding agreement between MS Health and Colonial, in which we state that we are the agent for TVT Capital and that we have every right to file suit against TVT Capital. But we funded it, we provided the money, we provided the monies according to the contract. So I'm not, it's pretty clear that we do have a monetary interest. We would not have filed suit if we did not have a monetary interest in receiving and collecting the funds that we were due.
Well, your adversary argues that you're just acting as the agent, just a mere agent. Why is that not accurate?
It's a bit more than that. Yes, we're servicing and we're the agent for TVT, but we did provide the funding. We did provide a portion of the funding.
And providing a portion of the funding means that you are therefore entitled to some monies. Is that correct?
Yes, Your Honor.
Anything else?
No, Your Honor.
Thank you so much.
Thank you.
Text away.
Your Honors, I just want to point out on rebuttal that the acknowledgement that my esteemed colleague points out does not refer to bringing lawsuits on behalf of TVT. It's in our appellate brief. First of all, it was a different entity, Fellis TVT Capital, not TVT Capital Inc. Second of all, the actual acknowledgement says, again, it's before the court, doesn't mention anything about bringing lawsuits on its behalf. Subsequent, after my client entered into the transaction, did TVT Capital then have an agreement with Colonial Funding and Capitus to be able to bring lawsuits on its behalf. At the time my client entered into the agreement with TVT, Warren Fellis TVT Capital, Colonial Funding did not have the authorization to bring lawsuits.
Sir, do you dispute what your adversary also said, that in fact Capitus purchased dollar amount of receivables, and that's the basis for its beneficial pecuniary monetary interest in the lawsuit, allowing it to sue?
Why isn't Capitus named as a plaintiff by itself?
I don't answer questions.
No, I say that rhetorically, Your Honor. Of course not. You ask them, I answer them, but I'm saying that rhetorically, Your Honor. If Capitus had the financial interest and had the standing to do it by itself, why didn't plaintiff name Capitus as a co-plaintiff in this matter? They're not named as an individual plaintiff. They're named as the servicing agent.
And we will ponder that question. Thank you so much.
Thank you.
Escrow Capital Management versus banks. Yes, please.
Good afternoon, Your Honor. May it please the court. Owen Roberts for the appellant, Ms. Banks. This is a case about a default judgment that was entered after she was never served. That's now undisputed on the record that service was not proper.
Why isn't it waived, counsel? 3 years of garnishment, why isn't it waived under some of our cases?
Especially Calderock.
Yeah.
So the reason for that is because those cases do not erect a bright line rule for waiver that would apply only to this one statute. Instead, waiver, as this court has consistently held, including in Hamapur and a number of other cases, is a fact-intensive question, and in fact, as a matter of law, cannot be found based on mere inaction.
Calderock involve a garnishment as well?
Calderock involved numerous things, one of which was a garnishment.
And so the Supreme Court relied, Civil Court,
Your Honor.
relied on Calderock. Why would that have been in error, if at all?
Because Calderock cannot be read to apply a bright line rule of the type that the civil court applied here. Calderock had many other factors going towards finding the waiver, including the fact that it happened after a full traverse hearing before the Supreme Court. The defendant in Calderock had actually participated in the underlying proceeding, had filed a motion for an extension of time to answer before defaulting. And the evidentiary record in that case, we had no hearing in this case, but in that case was found to be a record replete with evidence of a lack of good faith. In this case, in contrast, none of that was even engaged with because the question was read as a simple bright line rule. And subsequent to Calderock, in the HSBC Bank case from this court in 2009, we have a very similar fact pattern where someone is garnished for 10 months before filing this motion. And
3 years. I don't know about you, but if they're garnishing my salary for 3 days, I will know it. And, for 3 years, I mean, there's some kind of reliance there for 3 years, is there not?
To be clear, Your Honor, the issue is not that Ms. Banks did not know that she was being garnished. The question was she did not.
And no action is taken. So it's being garnished for 3 years. No action is taken until after 2 years, I think, right?
That's correct, Your Honor. And because Ms. Banks had no idea that when a judgment of this court is entered against you and someone is collecting money from you, there is a way to get out from under that. It's not that she did not know she was being garnished. It's not that she did not know there was a pretext.
There were no attempts by her to get from under it, as you just said, right?
There was no motion until 3 years later. As soon as she found out that this existed, I mean, this is undisputed in the record at record 13 and at record 47, that as soon as she learned of the existence of this statutory right.
It took about a year. When did she learn? It was about a year into the garnishment she learned about it?
No, it was closer to 3 years, Your Honor.
So it's your position that she did not know. I'm sorry, what precisely is your position?
She did not know that when a judgment of a New York court is entered against you, there's a way to get out from under it. That CPLR 5015.
She knew about the garnishment, but she didn't know what to do about it.
Exactly, Your Honor.
And so you're saying that's the basis to say that there wasn't a waiver, an intentional waiver of a known right.
The right has to be both known and intentionally waived. You cannot waive a right you do not know you have. Here there is a statutory right, which I'm sure.
What should happen here if it's established that either the defendant or her mother resided at the address at which service was allegedly made?
Well, if it was her mother, then that is not sufficient under CPLR 3082. It needs to be service on the actual person at the actual place of abode. If there was a determination that Ms. Banks was living at that address, this default judgment, there's no basis to get out from under it. She has made a motion under A4, which requires CPLR 5015 A4, which requires her to show that there was a lack of personal jurisdiction.
In other words, a traverse may resolve the issues with respect to service.
That's correct. The record has both sides' submissions on this issue, and I would submit that it's clear, it is undisputed that she was not living there. There's no evidence that she was living there. But in any event, if she was determined to have been found living there, then this default judgment would stand. But the question is, we never even reached there because without a hearing, a waiver defense was granted as a matter of law when consistent case law from the Court of Appeals and from this court says mere inaction, even thoughtlessness, those types of mistakes cannot be standing alone the basis for a waiver. And this is happening across a number of cases. There's a number of appellate term decisions and civil court decisions where this exact same fact pattern is repeating, and it's in this one area of law, waiver is being treated as a bright line box. And that is inconsistent with the standard that this court has otherwise erected for waiver cases.
Thank you.
Good afternoon, David. May it please the court, David D. Andrade for the respondent, Escrow Capital. It's respondent's position that the lower courts didn't err here. In fact, the civil court judge was compelled to follow Mitaku, which I think he did perfectly.
So is there, I guess the first question is there a bright line rule in the first department that there is a waiver under Cattle Rock as a matter of law?
It's respondent's position that that the judge in this case did not follow a bright line rule. The judge carefully recited what the defendant stated in her affidavit in his decision, and he noted that she was aware of the wage garnishment for a period of 3 years. He acknowledged that.
So let me stop you there. Isn't that essentially a finding, essentially that there was an intentional waiver of a known right then?
Yes. For instance, according to this court's decision in HSBC, where this court cited Mitaku, and it specifically said that the facts in Mitaku were delaying making a motion when there's a wage garnishment is an implicit participation in the action, and the intent and the knowledge is implicit. That's what HSBC says.
But what do you have to say about the Third Department case, 1983 case, Community State Bank versus Hankinson?
Okay. First of all, in the Third Department, there's another case that preceded that case called Ravona Realty, which is cited in our brief. And that case says that a defendant waives objections to jurisdiction when she doesn't act at the first possible opportunity. That's Third Department law. In the case that Your Honor mentioned, it was different than our case because in that case, the defendant specifically said that he was not aware of the garnishment, which really wasn't a wage garnishment. It was a garnishment of royalties. And the royalties weren't paid to him through a weekly paycheck, for example, where he would immediately realize that there was money being taken out of his paycheck. So there's no indication in that case that he knew that there was a garnishment. Completely different than the case than our case.
The court then goes on to sort of say, well, he denies knowing it. However, even if he did know, then it goes on to make further statements about it. So I'm not sure the Third Department found exactly what you were saying.
I would go back to Ravona Realty and in the Third Department and say that the rule is that if a defendant doesn't make a motion at the first possible opportunity, he's waived his
Well,
rights.
isn't that the issue? Because the argument is that she did so, she made that motion once she was informed that she could do so?
Well, what Mitaku says is that a defendant waives jurisdictional objections when she's dilatory in asserting her rights. And it's our position that the act of making the motion isn't the only part about asserting one's rights. Part of asserting one's rights is to find out what one's rights are. And in her affidavit, she doesn't say anything about any attempt she's ever made to find out what her rights are. And this Miss Banks she's no wilting lily. She called up the escrow's attorneys, and when she was notified of the default judgment, And she got onto the phone and she made basically legal arguments that she wasn't served correctly. This is a person who didn't know her rights when it comes to a default judgment. She was on the phone making a kind of a technical argument. I wasn't served correctly.
Is she a lawyer?
What's that?
Is she a lawyer?
No, but she has 6 semesters of college credits. She's gone to
6
school.
semesters, so she doesn't even have a BA.
She doesn't have a degree, but has 6 semesters. She has I think she went to school to be a medical assistant. When she got off of the phone, she says in her affidavit that she immediately called the U.S. Department of Education to see if they had any record of any money she owed on a student loan. This is a person who definitely has the wherewithal to do some sort of simple research, asking a question. I literally went on to Google and I put in default judgment, New York. On the first page in Google, you can find out every resource that you need to find out what you have to do in literally 10 seconds.
Thank you.
Thank you.
So the kind of testimony we just heard from my esteemed colleague is exactly why we need to have a hearing. If there's going to be questions
Was
about...
there anything stated in the affidavit as to what steps she did in fact take in order to learn how to overcome a default judgment or to vacate a default judgment?
So the steps that she took were when she was, the next time that she was in court and the first time that she spoke with an attorney, she learned that this existed. She raised the fact that she had a default judgment, that she had had her wages garnished. And 2-3 months after that is when the motion was filed.
For 3 years, her wages are garnished, right?
Yes, Your Honor.
And she does nothing about it. She makes no inquiry.
Well,
she makes no inquiry. Why is this happening? Is there anything I can do about it? Month in and month out, week in and week out, her salary is being diminished by this garnishment. And you are saying that she had no idea to inquire about this, to see if she could do anything about it. She just paid without taking any steps.
Your Honor, the inference should be the exact opposite way. Ms. Banks was down to $400 a week of take-home pay as a single mother of 2. She had every incentive
And her money is being diminished like that, and she makes no inquiry?
by an order of this
Why
court.
is this happening? Is there something I can do about it?
Yes, Your Honor. One of the inquiries that she made was when respondents' attorneys called her and they had a conversation. If they had wanted to get her on a hook for waiver, they could have told her that this right existed, that she had
When did this phone call take place?
in 2016.
And I didn't notice, is there anything in the record that talks about the exact amount of the garnishment?
Yes, Your Honor, there is. At multiple spots, at record 13 and at record...
And so what are we talking about in terms of the numbers?
Yeah, so the original debt that was allegedly owed, which is not owed, was a little bit over $10,000. To date, she has been garnished more than $16,000, and they're
How much
seeking...
per paycheck?
It's on the order of $400 per paycheck.
So $400 is coming out of her paycheck bi-weekly or whatever, and nothing, no statement, no follow-up, nothing?
Your Honor, we are here because she did follow up. I mean, you cannot relinquish a known right, even if it was a mistake, even if it was thoughtless. This cannot be the basis for waiver, certainly not without even having the civil court giving her an opportunity to be heard.
Thank you. Thank you both. Last case for argument, People versus Patrick Ross.
Good afternoon, Danielle Bernstein from the Legal Aid Society, and I have the privilege of representing Mr. Patrick Ross. Patrick Ross received the maximum sentence of a potential aggregate term of 8 years.
And why is that?
Because he failed a diversion program, Your Honor.
Because if he had completed the inpatient, the 12-month or 24-month, whatever, inpatient substance abuse program, if he had completed it and not absconded after 2 weeks in the program and not incurred 2 additional arrests and been out on a warrant for 2 years, the charges would have been dismissed.
That's correct, Your Honor, but that doesn't necessarily mean that the maximum term was the appropriate punishment.
That
for
was the
failing
promise. Was that not the promise?
It was, but that in no way cabins this court's ability to look at this sentence anew with all the mitigating factors present.
Okay, so how do we look at it if the waiver was valid?
Well, the waiver wasn't valid, Your Honor. I don't think it's an overstatement to say here that the prosecution's position that it was valid flies in the face of pretty much all the case law on this topic. The court told Mr. Ross in the oral colloquy he would normally have the right to appeal, and in exchange for entering a diversion program, he was giving up the right. That's it.
He got diversion over the people's objection, right?
That's correct, Your Honor.
The people did not go along with this plea.
Well, and they didn't because he would have gotten a conditional discharge otherwise, or dismissed.
Well, the people opposed it because they said there was no evidence that his problem was related to drinking.
Well, the record completely undermines that position, Your Honor. I mean, the pre-pleading memorandum that the defense counsel submitted demonstrated just how bad his drinking problem was, which the lower court
That's
credited.
self-reporting, right?
Yes, Your Honor, but I don't see how else that information would have arrived at the court.
Well, I think maybe if you had priors, I don't recall how many priors he had. I forget how many prior felonies he had and how many, 3 prior felonies. I don't remember how many prior misdemeanors, but none of them, I don't think, were for DWI, I don't think, or possession or anything like that, which would lead one to believe or leave a trial court or to believe that there was an issue in terms of substance abuse.
Well, it was an alcohol addiction, so possession charge would not have arisen.
The DWI would have helped.
Well, he didn't have a car and he lived in New York City, so that was.
I live in New York City. I have a car. But
Fair
anyhow,
enough,
I'm
Your
sorry. I didn't mean to.
Yeah, fair enough, Your Honor. The bottom line, though, is this is a case that is pretty much exactly the same as People versus Dollar, which is a case in which this court held that under exactly the same circumstances, consecutive terms of 2 to 4 years after someone was offered a diversion program and came back and failed it, and in that case was something much more egregious, the defendant there tried to smuggle 10 razor blades into a correctional facility. This court still said, where the defendant was a predicate felon, that the sentence should be reduced to a concurrent set of 2 terms. And that's really the modest request Mr. Ross is asking for here. This is someone whose offense came out of a disease. Yes, he failed the diversion program the first time in his life he was ever offered help for his addiction issue. And New York drug courts have made it incredibly clear that sanctions for failing a diversion program should be designed to motivate somebody to overcome their disease, not to punish them. The punishment he got here was for failing the diversion program, not for the underlying offense.
But wasn't it also coupled with the fact, as I said, that not only did he fail the program, he absconded after 2 weeks in the program, he's out on a warrant for 2 years, and the only reason why he's returned to court, he doesn't come back to court voluntarily. He comes back because he picks up 2 new arrests.
That's true, Your Honor, and to my knowledge, those arrests were never prosecuted. But the absconding is part of that failure that comes from people with this kind of disease, where when they're offered help, it's a really common outcome that they fail at the first time. The new arrests are part and parcel of the same kind of behavior he was committing as a working homeless person, committing minor offenses to support his addiction.
And also, he steals the wallets from gym lockers, and then the monies or whatever he gets, he's not buying food or buying anything to sustain himself. It doesn't even appear that he's buying alcohol. He's buying like clothing and luxury items, which I also found to be interesting.
Well, that, I believe, Your Honor, comes from a passing mention by the prosecution at the plea proceeding. But, the fact of the offenses coming out of this state of mind and this disease is still the pertinent issue here. And I just want to mention, in response to what Your Honor mentioned about that he didn't come back of his own accord, when it did come time for sentencing, he demonstrated remorse. He told the court, my intention was not to come back here. I wanted to go through the program and do the right thing, but I wasn't ready. And after a term of 2 to 4 instead of 4 to 8, he is ready to re-enter
You
society.
want 1.5 to 3
concurrent.
Concurrent.
That's the request, Your Honor, but we would be certainly thrilled with concurrent on the max.
And I'm assuming he's still incarcerated, right?
He is, Your Honor. His earliest release date is October 2024. And I want to mention also, when he gets out, his fiancee Jason, who was by his side in the beginning, his Aunt Marlene, both of whom I've had the chance to get to know and who are watching right now, will be here to help him re-enter into society.
Excellent. Thank you so much.
Good afternoon, Your Honors, and may it please the court, Emily Galtz on behalf of the people. Defendant's sentence was fair and appropriate and should not be reduced.
You want to address the waiver?
Sure, I can start with the waiver, of course. So the waiver was valid, which forecloses review of his excessive sentence claim. The judge Justice Nunez took care to properly separate the trial rights from the appellate rights.
So the judge said defendant would, quote, normally have the right to appeal, but that he was, quote, agreeing to give up his right to appeal, that's a valid waiver?
So she started with the trial rights, and she went through that he was giving up his right to go to trial, to remain
Did
silent.
the court explain the distinction between trial and appellate rights?
She did not, but she did talk about the trial
Let's
rights
go to
he
the
was giving
sentence.
up.
Why was the sentence fair here?
So the sentence was fair here because it was part of a was
How
not
many
really
counts was he charged with?
14.
And what did he plead to?
He pled guilty
to two?
to 2. So there was a
So
14.
what was the upper end if he had gone to trial on that? What was he facing?
I think the maximum. So it was 2 separate incidents. I believe,
He
and I
got
could
the
be wrong. The maximum.
didn't
He
But-
did get the
but
maximum.
The other side of it was he was going to get nothing.
Exactly,
if he
Your Honor.
completed the diversion program, which he got over the people's objection, and he walked out after 2 weeks, and he comes back 2 years later because he's got 2 other arrests.
Exactly, Your Honor. So this was a great deal. He had the chance to completely avoid any criminal conviction, any jail time, if he completed this diversion program. And after 2 weeks, as Your Honors have pointed out, he absconded from the program. He did not return to court for 2 years. He came back with 2 felony arrests for grand larceny and criminal possession of stolen property. And part of the deal, he knew if he failed the program that he was going to get this sentence. So this was no surprise. And I just want to point out, too, I believe the people partially opposed diversion in the first place because his crimes, maybe were not, it's not that he didn't have a drinking problem, but his crimes weren't relating to the drinking problem. He wasn't stealing and taking credit cards to go buy drugs or alcohol. At least that's not apparent from the record. Instead, what is clear from the
His
record,
record is theft-related.
it's all theft related.
Didn't he have an escape or something like that? Something.
I'm
weird?
sorry, Your Honor?
Didn't he have an escape or something weird like that?
He had, so he also had.
Oh, bomb threat. It was a bomb
Yes,
threat.
in South
yeah.
Carolina, he had convictions in 2001 and 2004 for bomb threats and false information, second-degree burglary. That was in South Carolina. But there was just no evidence that his current crimes were related to his substance abuse.
I just want to turn to the waiver 1 second. Was there a written waiver as well?
So, Your Honor, there was a written waiver. We do acknowledge that that wasn't really addressed on the record. There is, in the beginning of the proceeding, defense counsel does say he's signing the contract.
Right.
But there also was another contract, the MDC plea agreement, which also included provisions about waiving his right to appeal.
But it wasn't, the written waiver was not.
It was not discussed by the judge, but we believe that the oral colloquy was sufficient given all of the circumstances, defendant's age. This was not his first criminal conviction. Thank you, Your Honors.
First, I just want to note that the bomb threats are really unrelated to thank you, Your Honor, we agree. So, to Your Honor's point about the fact that Mr. Ross got the maximum here, it's incredibly likely that if he hadn't entered into an agreement with the plea court about this diversion program, that he wouldn't have received a maximum if he had made a deal with the prosecution and pled outright. So this outcome really does demonstrate how punitive in nature this is relative to his failure to complete the program, as opposed to the actual underlying offenses here. And that's really the issue here. It's not that Mr. Ross shouldn't or hasn't taken responsibility for his actions. He should, and he has. It just means that the sentence needs to be appropriately tailored to the actual underlying offense here, especially in light of the myriad mitigating factors here, including his disease, including an incredibly tragic upbringing that was marked by fits and starts, by losses of authority figures, by the foster care system, by grappling with his sexual...
How old was he at the time that he took the plea?
That he took the plea, he was 34, I believe, Your Honor. But the context that I'm talking about is a lifelong issue, not just of the addiction, but of not having a strong enough support system in his life. Even when he found that support system by reconnecting with his absent mother, who herself had an addiction issue, she unexpectedly and very tragically ended up dying very shortly after that reconnection. And notwithstanding all of that, he has shown the ability to turn his life around before. When he first was released from prison in South Carolina as a very young teen, he built a life there, he got a job as a store manager, he rebuilt that relationship with his mother. This is someone who has shown that he wants to turn his life around if given the opportunity. And I want to add again, this crime itself, it was nonviolent, it evinced no intent to harm another person, no one came to injury, there's nothing in the record that suggests there was trauma to the complainants. It was a mistake, it was something he should not have done, it was something he apologized to the court for, and it was something that 1 1/3 to 3 concurrent, or even 2 to 4 concurrent would address appropriately. And I just want to, I really appreciate your attention. I know it's the end of the day, and I appreciate the time you're giving us. I want to emphasize in context here, this sentence is harsher than sentences that people have gotten for violent felonies, including criminal possession of a weapon, assault, even attempted murder. It's just not appropriately tailored here.
Thank you so much. Thank you both.